Well, I hope that we are live now. Someone wants to give me a comment that they can hear me. Great. If not, I got to fix something as usual. It's working, Dan? uh, I'm assuming it's working and people can hear me. As soon as I get a hell yeah, I will start. 11 people are on. Quick chat, just say, hey, I hear you. All right, good. All right, so great. So I'll start. First, couple of things. Just to whet your appetite. Top 5 things I look for affidavits. So that's when you have a lawsuit against you and they don't have a contract attached to the lawsuit, you will have an affidavit. Let's call it an affidavit or a declaration, depending on the state. Mostly it's an affidavit. That's why I preach to a counter affidavit. So top things I look for to destroy their affidavits is check out the signatures and employment status of the affiant. I just did my last video where we found out that the person, Brandy Reardon, I think it was, no longer works at Citibank, even though she says she is, but a quick LinkedIn search and you can find that out. 2, are they claiming to refer to documents that are not attached to the affidavit? Why is that important? Because everything is hearsay. So for anything to come in, it doesn't necessarily have to be a trial, but for documents to come in on certain levels within the court, like a motion for summary disposition, that doesn't have to completely have an exception to the hearsay. Everything is hearsay, but you have to show, if you're depending on documents, show the documents and attach those to the affidavit. Number 3, personal knowledge of the documents that you claim to have personal knowledge of is a must under most states. The exception to hearsay is I'm going to say 99 times out of 100, the 803.6 rule is what states use, debt collectors use. Check out the notary public. Are they still licensed, or is that signing? Are they claiming to view the person signing it, that's signing it in front of them, and they're in Ohio, and the person signing it is in Montana? And I've seen that. And when I did a lot of foreclosure events, a lot of it, I became an expert at robo-signing. And so there's different formats and text of a signature compared to the actual print. You know something's up. The internet is your friend in that regard. This happens a lot. They'll attach an affidavit and a bill of sale and some other things. And I've seen this happen with PRA, portfolio recovery. They will the affidavit will contradict the bill of sale. It's great stuff. It's fun for me that happens, and it isn't a rarity because they don't care. The 9 out of 10 rule. Like Michigan, the Pew Charitable Trust found out that at least 7 out of 10 documents have default judgments. People just don't even show up. But 9 of them, something went wonky, and they settled for disastrous amounts out of 10. So it's a common docket to see all these cases called and no one shows up. You are the 1 out of 10, and we hope that gets bigger. So I have more to give you, but I will take some questions. Good day, everyone. Hi. And so we have, maybe I'm doing something wrong. Let me just see if I have questions. I probably am doing something wrong. Hey, I hear you. Good. Does anybody have any questions? Or I will read to you again. So what is your question? Anybody? Beulah? Come on. Is anybody old enough to know what that means? Beulah? Go ahead. I'm yours for as long as this takes. You know, I always go beyond what you're giving me. But if you have a question, I will listen. So, got a lot of people checking in. What was the mini Miranda that you can tell the collection agency? Okay, yeah. So I did a video. So Steve Kozar, 5335, hi Steve, asks, what was the mini Miranda that we can tell the collections agent? I know what you're saying. I came up with this idea of the consumer mini Miranda, and it's very good. And it is, you can be an evidentiary, an evidence genius. Here's the general rule. Law is law is made up of two things: the general rule and then the exceptions. And what happens is, I see this 30 years of doing this, judges live in the exceptions in certain cases. A good example is in collection work where everything is hearsay. It truly is. But they come in with the 803.6 exception to hearsay. It's really hard to read that exception and to fit that exception. So judges don't want to do the heavy lifting, and they'll just let stuff in. But a good way to look at things is the literal sense. What is the definition of an exception? It's like 1 out of 100. So if for something to come in, it's got to fit out of a 1 out of 100 chance of coming in. So you got to be careful there. So when you have the general rule is not to talk to debt collectors. I get it. You get sued. You want to call up and you're talking away. And now there's an even bigger problem. I am not crazy. I've done the work. Okay. The AI is capturing everything you say and then will morph it into what it wants others to hear. That's going to be down the road if it isn't happening already. So when you call up, you are giving away the ranch because you think once they hear my story or my mother died or I'm sick or I just lost my job or, GM's laying some people off and we're going back to work in July. That's not anything you want to say just for the very reason that the AI is capturing it and creating words for you. It's going to happen. But so that's the general rule, do not talk to debt collectors. The exception to that is if you must do that for some strange reason, give them the mini Miranda consumer rule. And that's what Steve's talking about. You say, and this is an evidentiary rule, I'll just refer to it in Michigan, which is 408 MRE, Michigan Rules of Evidence 408, that says settlement discussions are not to be brought to court because were we to allow settlement discussions to come into court, nothing would get settled because everybody would fear talking about and worrying about that their settlement discussions were used to prove liability. An example is you're on a landlord's property, you fall down the stairs because he hadn't checked the stairs and it broke. So now you're injured and you have a lawsuit. He quickly fixes it and says, hey, I fixed it. So you go to court and go, hey, see, he did break it because he fixed it. Well, he would not fix it if he feared that would be used against him. And that's the law. General rule is settlement discussions can't come into court. So you are then free to settle your debt. So when you call a debt collector, say, I am calling for settlement purposes only. I don't admit to anything. I just want to see what is owed and why. And if you could say that 3 times in the same conversation, A, you protect yourself. B, you're being recorded always. C, they'll know you're not the average barn door. You are someone that knows what they're doing. I hope that helps you, Steve. And now because I drone on and on and on, I've missed a whole bunch of questions. So Tony, thank you so much for doing this. I'm in California. I was wondering if I can use your materials to deal with the original creditor. Oh yeah, I just did a video on that. And California is one of those great states, very defendant oriented. Do whatever you like. And that's all it Rosenthal Act is what I preach. If you go to my video, state laws separate from the FDCPA, that's one of them. And for example, Florida has the FCCPA. It's better than the federal rule, right? So have at it. Shams Buckley 9951 says, when the plaintiff's MSJ was denied, and that's the guy suing you, and in the answer, my evidence wasn't heard by the judge, I need to file my own MSJ so the evidence will be heard. No, without telling you how to run your life or what to do, not giving you advice, why would you do that? It's a lot of work, unless your motion says the same thing that they're saying when they filed a motion against you, which is they don't have a genuine material dispute here. That would be your argument. There is no evidence that I own the debt, or whatever it is you can show that they have not brought. You can say their claim dies. So that's why you bring that MSJ to end it. Housekeeping, very practical thing. And I think this is what you're saying, Seamus Buckley. If the court is denying their MSJ, that's a hint and a half to you that maybe you need to bring, but bring it right. Look at the rules, and if you can show that there is no dispute, a material dispute, a genuine material dispute, you win, hopefully. A copy, FJS, FJSO says, I got a cold, it keeps coming back. A copy of the summons does not have the collector's mini Miranda. Can the attorneys add it to the documents and while serving you, or needs to be the same? You're missing it. If they have it on there, they violated the law. 1692 E11. 15 USC 1692 E11. You want it to be on there in some respects. So Morgan says, yeah, so I turned in a motion to quash. Upon doing so, I made a phone call to the courts and was told that I have another case I'm being sued for by Capital One. I guess missed the court date. I think you might be saying you've got a judgment. If you can show, and I think you can, legitimately you had no concept that you'd been served, if that's the case, you're likely to win a motion to set aside. Morgan, I have another one. I was never served papers for the one missed, though. So, same. Okay, yeah. So when I go to court for the one I missed, what should I expect? You're not going to court unless you file that motion to set aside. And then always, this is a mistake people make. They forget to do the notice of hearing. Don't forget the notice of hearing. My Michigan Cap 1 Discover suit lists count 1 breach of contract. Does that mean that they must come up with the original contract? Only if they want to win. If they've come up with an affidavit claiming a replacement, that's a separate rule. Let me give you the top 5 things to attack the Cap 1 Discover merger with. Number 1, proof of merger. I'm finding the proof is for shit. It's just, and they've added stuff. I just did a video last week on that. Even the stuff they add just gives them more conditions they have to meet. Proof your specific debt transferred to Cap 1 is a must. So what if there's a merger? A merger is not an assignment. An assignment is an assignment. So all you got to ask for is just show me where my debt, by the way, think about this. Discover Bank has the debt, it securitizes, it's in a trust. Cap 1 comes along May 17th, I think, 2025, it was official, and says, hey, we've bought it. But it has to go from securitized trust Discover back to Discover, then to Cap 1, securitized, yada, yada. That's a tangle web that can't be untangled. Number 3, a mini Miranda usually shows up on a lot of these cases. Well, that means the person suing you is a third-party debt collector. I guess it is securitized. Why would they be saying they're a third-party debt collector? Number 4, securitization. That's a securitization mess. So you've got a lot of pressure points, as they say in martial arts, that you can push upon to win that case. Number 5, which governing law, which contract rules? And you now have 2 governing laws. I think Discover is Delaware, Cap 1's governing law is Virginia. Depending on what state you're in, you've got 3 states there now where you can go, hey, I think I'd really like that governing law. And then you make a motion saying that's the contract, but there is no contract. So act accordingly. Benjamin says, if you're on the fence with getting your product, what time frame should you purchase? It's for getting your product. I don't know what that means. Come back to me. Mr. and Mrs. Cunningham, I received a summons from Coast Assets Manager. Maybe Crown Asset? I sent a letter to CAMS, Crown Assets, and I still haven't heard from them. Why are you sending a letter? It goes against everything I teach. Sorry. You have to answer the lawsuit. You have to have a counter affidavit attached to answer. And if you've got 30 days, you've got till the 12th. Get ParkerGPT or do it yourself. Or there's cheaper versions out there, but not so good. But I don't know why you send a letter unless you sent a letter, but you still plan on answering. Do not answer. Is that without prejudice? Is that a without prejudice rule? I'm not sure what you're referring to. Let me see. I'll go back and see if you asked a question. The without prejudice rule is twofold. If you win something, but it's without prejudice or a case is dismissed, it can be brought again. If you win something with prejudice, it cannot be brought again. There's no exceptions to that. Other than, now let's just say there's no exceptions to that. So thanks for doing a Q&A. You're welcome, Seamus. From TikTok, question from La Rubia. Do you suggest sending a debt settlement offer to original creditor? Depends why. Meaning, make sure that's covered in, this is for settlement discussions. And if if you're worried you're going to get sued, that's probably okay to do. But make sure it's covered in, this is for settlement discussions only. Don't give too much of a story. It doesn't matter to them. They just use it against you. What was my general rule at the beginning of this video? So their initial letter says that after CFPB complaint, they say they've been hired to represent. When is the latest I can bring a counter? I don't know what that. So Rena says, when's the latest I can bring a counterclaim? So if you're in Michigan, for example, the rule is you bring the counterclaim with the answer. That's the rule. However, you're allowed to amend your answer. And in Michigan, and when I say by example, it means that all the states follow similar things. You have 14 days where you can amend your answer. Well, then you can then add a counterclaim, because there's a thing called the retroactive relation back doctrine. I kind of added some names, but when you file an amended anything, it goes backwards. It's retro, man. So that the thing that it's replacing is as though it didn't exist. So everything starts again. So you have a right then for another 14 days to add the counterclaim. So there's ways to around that. So let's say you missed some dates. You can do a motion to amend. I do this, and it's probably not nice of me. If I ask them, can I amend my complaint? They'll say, sure. Oh, sorry, my answer. And they'll say, but you can't have a counterclaim because they know I'm going to come after them. So I have to go do a motion with the court for an answer, amendment, and then I'll add the counterclaim because it's a new day, whether I ask permission or not. So all I have to show the court is my proposed amendment that I've done videos on this. So if I'm amending, I can add a counterclaim. But the rule is if you don't, at least in Michigan and around the country, if you don't amend within 14 days, you have to ask the court's permission. Now, again, you can call the other side and go, would you stip to this? But they're not going to stip to, if it's early days, they know you will win that motion. If it's early in litigation, but you missed the 14 days, so you have to bring a motion, you will win that. 99 times out of 100. So they know that and they'll agree to it, but they won't agree to a counterclaim. So act accordingly. Seamus says, again, Seamus is dominating. I showed that they had no standing, their evidence used the wrong dates, but the judge stated, though my evidence was seen by her, it was not heard. If not a motion, go for a motion summary judgment if you think you've met the genuine issue of material fact rule, is the best way to approach that question. So motion to dismiss, but I'm not sure what state you're in. So, hi, Brian. Midland left a rude message on my voicemail. They talk about your mom, but they keep calling me from numbers that are disconnected the next day. How do I prove it was them? Well, you can Google that, but you don't. By the way, the new CFPB rules say you're only allowed to be called 7 times in a week. So that adds up pretty quickly. But if you suspect they're doing something wrong, send them a cease and desist letter. Now, they possibly may sue you, but they were going to sue you anyway if they were ready to do that. And you don't have to take that nonsense. But the positive is they're more than likely to go against your cease and desist and keep calling. So the answer to your original question is Google their numbers. Yeah, I get what you're saying. But send them a cease and desist and list the numbers saying, please do not call me from these numbers. I suspect these are phony numbers. When you write something in law, you're really talking to 2 people. I'm talking to 1 person, but I'm really talking to 2 people, 3 a jury. I write something as though I know a judge is going to read this. So my emails or letters will go, look, I've really tried to work hard with you, and you keep refusing to do the same stuff you do all the time, and you're really being unprofessional. I'm talking to the judge because the judge is going to see that letter. So limit what you have to say, but point out what they've done wrong in your letter because it could be Exhibit A. I got served, Ninjatronics says, January 15th from LVNV Funding. I filed an answer on the 16th and sent LVNV Funding discovery and another motion I can't recall. You're a busy litigant. Am I ahead of most? You can't do discovery in most states until the court gives you permission, or a lot of rules are adopting the initial statement rule where you have to give an initial, what's it called? This is long days. But you would have to show your initial form of, it'll come to me and I'll say it again, but you have to do a precondition to discovery. You have to show them your initial statements, showing them what you hope to depend on, witnesses, evidence. Once both parties have shared that, then discovery starts. Or in Michigan, for example, again, that is adopting that initial statement rule, you have to go to a pretrial. Then the court will give you whatever you want. But you don't do it right off the bat. It used to be in Michigan, you could do that at the circuit court. You'd send an answer or a complaint with a ton of discovery. And the only drawback was you had to wait. It had to be done in 42 days or something like that, as opposed giving them 42 days as opposed to giving them 30 days to respond. But generally, you can't do that off the bat. Generally, there are exceptions. I guess today's theme is general rule exceptions. I had a debt case, says Diana, with Midland 10 years ago. The case went dormant. After 10, they tried to revive the judgment with a writ. It was returned nulla bona. I don't know what that is. That's awesome. This case is closed. Well, just go to the court docket and hopefully it says that. In Michigan, again, I use that just as an example. There is a 10-year judgment rule. You're allowed to have 10 extra years if you file a motion to extend that to 10, and you can do it ex parte. I'm talking about what a debt collector can do within the first 10 years. And I find it happens where the debt collector will file a motion for the next 10 years after the first 10 years has passed. They've got 10 years to do that, and they miss the boat. So that's the rule in Michigan. There are similar rules around the country. What do we say? Somebody at TikTok today told me to file a motion to compel first before I do anything. I don't know. You're gonna have to explain more on that. It's from collection stuff. That's me. Steve, would it still be a FDCPA violation if a collection? I'd like to do that. Would it still be a FDCPA if a collection agency calls you before 8 a.m. where you currently live, SCT? But I imagine they think I still live EST. Don't be thinking for somebody else. Somebody says, my concern is why after giving all my information already, the system decided to file a motion to compel arbitration. Can you look at my documents prior to file? Can you? I can't answer that. ParkerGPT drafted my answer affidavit, refined them, then said to file a motion to compel arbitration. I haven't been served yet. Why the shift? Can you review my docs? Without sounding mean, whatever you put in is what you get out of it, sort of like weightlifting. So it'll give you, I'm not yelling at you, and yell me if you want, but I put the rocket ship prompt there so you can refine your request, but I don't know what you put into it. So you don't want to be in arbitration. I treat arbitration like the plague. Are there exceptions to the general rule? Treat arbitrations like the plague? Yes. But it's not a way to go because, number one, you lose all your evidentiary rights, all your rights to show how they have not proven their case go out the window. Procedure, court rules, a third-party neutral arbitrator. Remember, arbitration, the arbitrator is arbitrary. See, I think that's what the AAA arbitration people stands for. Arbitration, arbitrator is arbitrary. He or she may not even be an attorney, and he or she is not going to accept your evidentiary points. And by the way, in some cases, when you agree to arbitration, you completely give away your defense or your ability to attack them, because a lot of our stuff is based on the rules. They have their own rules. Act accordingly. From TikTok, Capital One is suing me on behalf of Discover. I just answered that, and they wouldn't agree. Don't ask the plump fox to help you, the hungry chicken. Sent for man's demand for discovery to Cap One for Discover CC car case January 29th. Court is on Feb 23. If I didn't give them 30 days, can they not perform? The two are separate things. I don't know why you're going to court, but if it's 30-day rule, then they got 30 days to respond, whether you got a hearing or not. So I'm not sure about that. Mr. and Mrs. Cunningham, I sent a letter to Cam and court to tell me what and who is. So you would never send that to the court. I'm in California. My date is scheduled for April sometime. My date. You're having a date? Let me know more about that. Deckard, my $11 million cross complaint is unopposed. Really? And the judge granted it for it to proceed to trial. I want to take the case? No, thank you. I threw rocks at a lot of windmills in my 30 years. That's why I have the gray hair. It's not about the money. Everybody likes money, but no, thank you. And I don't practice. I've done a lot of federal stuff in California, but not state. Thanks. I'm in Oklahoma. It's not too late to file a motion to dismiss. Never too late unless the court says you can't. Hey, Brian, great to see you. Appreciate the work. Hey, Chris Law, how you doing again? From TikTok, what should we ask for in a debt validation? See every debt validation letter, probably over 100 in killdebt.com. Statute of limitation expired over 6 years before they filed their complaint. Nice. You've got a great case there, Seamus. I love that case. But is that your statute of limitations in your state? How about the governing law of the state of the creditor agreement? If it's in, for example, South Carolina, it's only 3 years. That'll add some fun to your lawsuit. Aztec. I beat Mandridge Law for $15K from Lending Club. Oh, good. Cross River Bank. You instill belief in me. I did hire a local law firm, but initially represented myself from the beginning. Good for you. The local law firm should pay you and me. If no bank can lend their own money, isn't it everything debt collector issues and would have no standing? It sounds a little bit sovereign citizensy. I hope that's not where you're going as far as the bank, but you can always send a dispute letter seeking validation. Shayna Shields, I filed a counterclaim against UHG. Good. I haven't seen them around once. I think something's going on with them. For FDCPA violations. They left the state that I'm in, and I had some fun with them. For FDCPA violations, but the JP judge said that because I used federal violations, the case has to be heard at my state federal court. No. It only has to go to federal court if the other side you're opposing removes it. And they've only got a certain amount of time to remove it. You can remand it if the reason they're removing it is false. And then you get attorney fees and costs. But it's not up to the judge to do that. Can he? I think the words are sua sponte. I don't believe he can do that because he would not be impartial if he's acting for the other side who has not filed that motion. It's a motion they have to file. And if it's after 30 days, he can't kick you out of that, generally. When do you know when the original creditor sold the debt to the trust? Great question. You can do your homework. We've got a tab for securitization on Kill Debt. You can ask. You, like I said, you go to the SEC, EGDA, but we have it. We have all of that in killdebt.com. But that is a good question. As far as the date, I'll tell you, I do a lot of citizen bank cases, and they're getting into just personal loan field. And when you do a discovery, you ask for discovery, they accidentally tell you all the time. It's not this was securitized. They'll say this was transferred. And so discovery is probably your best bet. But if you're having a defense, you can allege. Like I just did a Cap 1 case today. Let me see if I can find it for you. And I'll tell you what I did in my answer. I'll do a video on it Monday. How's that? I'm sorry for the delay. Let me tell you what I wrote. That's not good. I'm sorry about the dead air. I'm not a radio guy. I'm with you. Hold on. There it is. Good. Okay. So I wrote, the foregoing securitization structure is a matter of public record and is verified by the following available filings with the United States Securities and Exchange Commission. A, Capital One Multi-Asset Execution Trust Prospectus, SEC Form 424B5, filed with the SEC under CIK number 000, blah, 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 states that Comet, that's the name of the Multi-Asset Execution Trust, primary asset. So I went and found it. I think I got it from Kill Debt. So you can make, and that's in my counter affidavit. That's an enormous amount of information for pleadings. That's more than enough. That would be the answer to the question. It's all in Kill Debt. When do you know? Okay, done that. That is what I get for using. Use your. All right. So someone says, got it. Ninjatronics. That is what I get for using ChatGPT. I will use your ParkerGPT. Okay, so I don't know how to say this. I created killdebt.com. I have done the work with ChatGPT. It actually has gotten worse. I don't know how you can evolve and get worse. And I've compared, my last video compared ChatGPT and ParkerGPT, and I used Claude. I didn't go, in my opinion, I asked Claude to do an independent, and it did, and we kicked their butt. Now, why I won and why you win by using ParkerGPT is we only do debt defense. When you use ChatGPT, like Ninjatronics is talking about, your answer, what answer do you get? You get the internet. It's not devoted to debt defense. And in that video, it's my latest video, I'm quite detailed about how bad the job that ChatGPT does. Now, if you're really mad about your boyfriend not talking to you enough, or she's complaining about you, or he's complaining about you talking during the football game, that's what belongs in ChatGPT. If you do a boost plan, says Benjamin, and then you don't renew, then you need it again 5 minutes later. Is your information saved? I'm going to give you a conditional answer. If it's after November 10th and you bought it with the iteration, the new 2.0, there's a good possibility it may still be there. That's my general answer. Benjamin says, when will your ParkerGPT be updated so it stores your personal documents so you don't have to reload them? See, 2 weeks ago. I believe we did that. Natalie, if you're still here, if I'm wrong, text me. But I believe the developer just did that, Benjamin. So I think you're in luck. Deckard Rick, 11 million cross complaint. Filed cat. I don't want to read that. I don't want to bother you with that. Shanus Shields sent a lot of UHG sent a lot of bank statements, but one statement is the charge-off closing statement stating a zero balance. That doesn't mean you don't owe. I'm going to cut it short right there. Natalie's telling me something right now. Yes, you're in luck. Let me go back, and this is for everybody that's thinking. ParkerGPT will store your personal documents so you don't have to reload. We have a tab now. It was told to me that it's like having your own cloud, I guess, right inside. So it stores your specific documents. Come back to it. Shoot, what did I do? I know I put a bill of sale somewhere. You have a briefcase. I have developed a briefcase. It's your briefcase, just like a lawyer walks around, or used to. You've got a briefcase. It stores everything. It's like your own little law firm. And we will one day be creating an iteration where we will have a law firm. So people can come to us as lawyers, non-lawyers, and have their own ChatGPT personal to them. Because I can't call it ParkerGPT. It's not ChatGPT. It's your own chat box, personal to you. That's how great the developer is going. Is there a way to schedule a one-on-one consult with you? Yeah, just goes to KillDebt, and we have 15. You can buy 15-minute increments, but I'm going to cut my own throat here. If you've got ParkerGPT, save your money. Use that first, and if you really still need me, you can buy 15 minutes. People generally buy 30 minutes of my time, and I just take what you show me, and I give you an opinion of what I would do. I'm not going to give you legal advice. And I get what you're saying. There's still this, and it's right. As good as ParkerGPT is, we want still the human touch. But I must tell you, fight fire with fire. And debt collectors believe in AI. AI believes in you. Fight fire with fire. And I have 30 years I've done it all. I've talked to, a lot of times I'll do a video against a debt collector. I'll call the owner, or I'll call the guy that represents them nationally. Hey, what do you think about that? Because that goes into ParkerGPT, that special knowledge, everything. I guess if you'd really want to, my stuff is behind the curtain. You know, we like to know behind the curtain. That's me. That's why I have the gray hair. Is there a way to reschedule? Okay, Moose Man, do debt collectors show the name in the complaint of the company they bought the account from? And does that mean they work for them? No, if they bought it, they don't work for them. An assignment or a bill of sale means, and actually, your question is a great one. Those sales are bought as is without recourse. The person selling the debt for pennies on the dollar knows it's ship. It's ship. So they put in the bill of sale. Look, the brakes don't work, okay? It's as is. It literally is an as is sale. Some debt buyers, sellers, original creditors will go, we make no warranty about title or merchantability. That's really damning. That goes into every counter affidavit quoted and in my answer, because they literally are saying we can't really prove that there's ownership. That's what failure for warranty of title on this conceptual level. So this is actually a good question. But what they will do to kind of buttress some support that they own the thing, even though they don't, they'll go Midland Credit right in the caption, so the judge reads it, as assignee for Citibank. But they've got to prove it to say that. But that's what they do. Because 9 out of 10 of you, not you guys, are not going to answer the lawsuit. So the judge takes it on gospel. So Sensei Parker, your tutelage is much appreciated. Thank you for LD. Some Samurai. Just served with the Simmons from Capital One, says Kamish. Well, see what I just said. That's been a frequent flyer today. Okay. Wowie. Original creditor affidavit is identical to 10 other affidavits on the court docket. Does this challenge personal knowledge? I think you've got something there. How do you have personal knowledge if it's exactly the same? But I would read a little deeper, and I would come up with a top 5 list that every one of these 10 things has. I'm a big thing on top 5 lists. So just to show the court. And I would also do, like I try to tell people, we have an ADHD society. I have it. I have to take a little pill that's the greatest. I put everything up front in either a preliminary statement or when it's a velocity or a lot of chain of title, I'll do a synopsis because I know he or she's not going to read to the end of this. And I want the lawyer to see that. That settles cases. So I recall, says Ninjatronics, the other motion, I'm not going to get into that because I got to go to new people. Sorry about that. La Rubia, I sent a question on Instagram, desperate for your opinion. Are we hooked up to Instagram? I'm not. No. If you could. Oh, you're probably watching it then. Just send me the question through chat, the same way you just did. Dirt Donkey. Hey, Brian, quick response. Quick question. I'm going to give you a quick response. I'm stepping on the battlefield with PRA. In their original petition, they didn't attach any documents. Can I object when they try to introduce No, depends on, that's a big, no. Your defense and counterclaim is there's no proof. That's even a motion to dismiss. And so you'd file a motion to dismiss if you feel inclined. And you're going to win two ways. The court's going to go, you're right. Or he's going to order PRA to come up with documents. And Michigan's example, the rule is if you don't have it in 14 days, you just defaulted on a court order. It's likely the case goes away. It's likely the case goes away when you file a motion to dismiss. Most states say you have to do one of 2 things to not get defaulted when a complaint is filed against you. A, answer it, or B, a motion to dismiss. Motion to dismiss stops the 21 days running. Check your court rules, but I'd file a motion to dismiss against PRA. That case will get settled. Excuse me again. Deckard Rick is asking, I paid $175 during Labor Day weekend. We haven't rescheduled. I'm not sure what you're asking. Deckard, I'm not sure what you're saying. Why don't you write me an email at brian@killdebt.com and I'll try and help you out. Because that's not for this deal, but go ahead, you get my personal email. Benjamin, how often is your yearly plan needed versus 1 month? How often is your yearly plan needed? I think you save 7 months, 5 months, 5 to 7 months. So it's $175 a month. If you do a year, you save at least 500. Don't make me do that. 150, 350, 7, 8, 75, I think. So I wouldn't do that though. Go for the 3-month plan unless you can see down the road you're going to have several cases. So don't get the year plan. I know I'm cutting my throat again. Unless you know you're going to have a lot of cases, meaning that go to court. Then it makes sense. Rather than paying $175. You're going to 12 times $175. Oh my goodness. If you do the 3-month plan, you get a free month 4 times a year. So I think if my math is correct, it would be better to do the year-long plan if you're going to have cases that are going to keep you in court for a while. I hope that makes sense. The judge in my case wants me to submit a dispositive motion by next week. What do? I'm trying to get the case dismissed. If I hear between the lines, the judge is on your side. Or you've been talking about this and he says, look, you got to do it by next week. Natalie's sending me 2 messages. Maybe just posted from Instagram. Person 3 messages that wouldn't fit on the page. All right. Hopefully it shows up. Will ParkerGPT help eliminate negative items on a credit report? Absolutely. And there's great little videos. Somebody asked me about that and I sent him a dispute letter and I sent them the videos, the 5-minute videos on my killdebt.com. Showing you how to do all of that. But we've got all the letters. Just feed it. How do I put this? We have to audit what goes on. So we've had some weirdness initially. So we have to take a look at things. And you'd be surprised what people upload. But you can upload a credit report. We have complete privacy and all that. It's your little thing and it's your briefcase, but it will do the work that you ask it to do, and you're not the first. So it's every time something is done or uploaded, that's new information for it to get better and stronger for you. I feel most comfortable using ParkerGPT as an analysis and learning tool, says 4LD Samurai. I often show it documents I create rather than having it create documents. Oh, that's a great use too. Francella, I have ParkerGPT. I have a pending Wells Fargo lawsuit. I got a couple on there. And ParkerGPT changes my answer and affidavit a few times. Today it told me to do a motion to compel first. If you are doing discovery and they won't give you the answers or the answers are for shit, that's why you do a motion to compel. I'm wondering what you told it. Rena, if I can prove a dispute with Discover and that they did not do a validation debt, will that cancel one of the elements of the account stated claim? That's a great question. And I'm glad you asked that. So generally, a debt collection lawsuit is a breach of contract, count 1, account stated, count 2, because they figure they're going to lose the breach of contract, and then unjust enrichment, which is just a throwaway. Every count has to be proven. There are elements. So go to the state elements of what your state requires. The reason I hesitated there, here's what I wrote in the counter affidavit on a Cap 1 case today. The plaintiff appears to be suing under an account stated theory and not a breach of contract claim. Notably, the word debt, does not appear anywhere in the complaint. It claims I owe a payment on an account and not a debt. This is significant because an account stated claim requires, and these are the elements, mutual assent to balance stated, which I have never provided. I have not agreed to an amount due with Capital One. So that's the counter affidavit addressing your question. If there's an element missing, you win. So put that in your counter affidavit. But first, I counsel you, not on your case, but personally, go and find out what your elements are. And if they haven't proven those elements of those 3 claims, it's in your counter affidavit and in your defense. Remember, as I started at the beginning, a contract case has elements. You only need to win one of those. You don't need to prove all 4 for ship, just one. And then if they can't prove one of the elements, the whole case falls down. Top 5 easiest. Going to take a quick break in that I did a list for you. Top 5 easiest debt buyers to beat. Midland Credit Management. Boy, they're easy. Now they're going to be hard with me, but they're very pragmatic. Portfolio Recovery Associates. Why those 2? They're both publicly traded. They're so big in the billions. They buy tons of debt. They are publicly traded. I want to tell you a personal story of why I bought a stock in the company many moons ago that owned Midland Credit Management, but I won't. But I could see where they were, how busy and good they were getting. It wasn't inside information because I was suing them every day and they had so many lawsuits. But those 2 are they have to protect their backsides. They have shareholders and they have a public optic. So if they're busy getting a reputation for fighting people, that's not good PR. So I think that's why they settle easy, and because of me. Jefferson Capital is number 3. By the way, according to the Pew Charitable Trust, I believe, Jefferson Capital files the most lawsuits in Michigan. Crown Asset Management, number 4. They'll settle. They're pragmatic. They're just old debt. Any private student loan is number 5 easiest to beat because they are really just debt buyer cases without any proof. They actually get put a lot of times into what's called slabs, student loan asset-backed something. Slabs, SLABS, student loan asset-backed securitization or securities. And it's just, I used to do a lot of NCSLT, National Collegiate Student Loan Trust. They were filing $800,000 a year at one point. And I found their pooling and service agreement, and it literally said, if you can go look, if you have one of these cases, at Article 12, and it's in Roman numerics, Article X bar, and it says, National Student Loan Collegiate Trust agrees to assign this to the trustee. And here they are suing my guy. Should have been the trustee. And that's in their paperwork. I'm telling you. LaRubia, original letter sent Minnie Miranda, responded with debt validation letter. They sent 19 pages of nothing but junk and half an account statement. Then I opened a CFPB complaint. Okay, CFPB is a waste of time. There are presidential administrations that fund that thing, and it does good work. It's anti-business, some say. The current administration gutted it. It is toothless. It just doesn't have any value. However, filing complaint and proof of complaint, the person you're filing against will answer back. And there is still mechanisms in the CPFB to handle things. And for example, back to PRA, they have a $24 million consent judgment they signed with the CPFB in 2023 before the current administration came in. When the current administration came in, I'm not taking sides, I'm saying it gutted all consent orders were about to sign, especially in NCSLST and student loans. It stopped all of that. But in 2023, it was the Biden administration, PRA signed off on that consent order from the CFPB. So that's locked in. They can't, and they owe $24 million, and they have to provide a shipload of paperwork before they can file a lawsuit, which I've yet to see. So I use that, and it's in my answers and counter affidavits. So CFPB is good for you. Midland Funding has a lot of these too. I say Midland Funding. The consent orders, most consent orders from the CFPB are signed by the people that are having to pay this money, because it's just like they're settling a debt just like anybody else. So that's where the CFPB orders are good. Go to their database on CFPB orders, consent orders. Also, they have a good database for credit card holder agreements. So that's where they are still good. So that's a waste of time otherwise. I have had a problem with GPT not remembering my documents, dates, and names. You just said GPT. Are you talking ParkerGPT, Michael Yates? LaRubio, I did now. Collection stopper. LaRubio sending on your behalf on Y2. What? Sorry, I'm burnt. I should have brought coffee. Nintronics, no worries, ADHD patient myself. It calms me down. I used to be in a line at the grocery store before the pill, and let's say I'm 5 back, and I'd look and I go, hey, that's right. Wait till you get to actually buy the stuff before you take the card out of your purse. Oh, great. You're going to use cash. Great. And I'd just be a nut. I say that because I'm not patient when I'm unmedicated. But boy, am I focused. So yeah, ADHD, I got diagnosed late. And then I was able to, and with my friend's help, to go, that's why you were such a butthole. That's why that happened. That's why you don't give anybody an opportunity to speak first. That's why you're so impatient. But that pill, I got rid of a ton of stuff, and man, did my work improve. Readying a motion to dismiss, says WTQ, which will stay discovery and answer in, will it? Yeah, I guess, in Georgia. Will setting hearing on motion. Motion will cite securitization standing. At what point should you expect bank to propose a settlement? I have no idea. If they're scared of your motion, right away. Collection stopper. Someone said I know what. So this is Natalie sending me these questions. They closed it and said they'd respond directly. The letter they sent me had someone else's account number and the file number, and they changed the from mini Miranda's to now we're hired to represent. Dude, you got to write that again. I can't understand that. I want to understand it because that sounds like good stuff. LaRubia asked, original letter sent Mini Miranda. I responded with debt validation letter. They sent blah, 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 and then they closed it and said they'd respond directly. The letter they sent me had someone else's account number and file number. I'm waiting in the weeds for a lawsuit on that one, but that's just me because you got great stuff to smack them. Fixing to smoke PRA. You know, I smoked a lot of PRA back in the day. I'm just kidding. On February 10th, if ChatGPT can remember my documents, well, stop using ChatGPT. Capital One sent the Discover card member agreement, but it's not the same one I have. Looks like it's just a random copy. Is that acceptable? See all my videos. If you are being told you violated or breached terms and conditions of an agreement, you have a right to see the agreement and those terms and conditions. And here's a little tip. Let's say you took the debt out 2018. You'll see on the bottom of a lot of these agreements, which aren't signed by you, it'll say 2020. It's a new. Well, you didn't have the thing in 2020. Now, they can make amendments, but it will say amendment. It won't say and this is what they do. They just give you a form contract. So A, it hasn't been signed. B, those aren't your terms and conditions. I had a good see you later. No, C is, it's not the same terms and conditions as 2018. It may not even be the same governing law. You've really got to hold their feet to the fire when they supply something that doesn't have your name signed on it. The older, the better chances that you actually signed for it. Moose Man, I got worried because of the Discover and Capital One merger. I didn't. I loved it. When I saw that mess, I'm like, oh yeah. Does ParkerGPT help to file a complaint against debt collectors? Yes. And hire an original creditors and help with motions. I use it every day. Yeah. You ever going to do the video on securitization of mortgages? I'm not going to do anything with mortgages. I did a ton of mortgage foreclosure cases, keeping people in their house. I kept some guy in there for 10 years. But every night I drove back home, and this is Michigan, if there had been a bridge, I would have jumped off it. It was so depressing. I lost a lot of my life trying to keep people in their house. I will never do that again. I don't want to. The only thing I'll do for you is zombie debt, because I see that coming and it's taking people's houses. By the way, the zombie debt, stop. Don't let them get away with that. If you're listening to this, just because the debt shows up and they claim they own it, it's just an old debt. I have read about so many people losing their homes or having to pay a debt on debt that's 10 years or 15 years old that doesn't, and it's just a debt, old debt, really. I don't know why lawyers aren't doing something about this. Have you been seeing anything with Southeast Client Services? I have never handled one of those cases, but I'll look. I'm in NC, by the way. Didn't know if this state helps the consumer any better than other states. Look up the right to cure laws. Look at your state law. It's a Republican House and Senate, but it's a Democratic governor. It's usually how they roll up there. So there's some compromises for consumers up there. LaRubio, keep reading, please. These guys are so grimy. Attorneys or debt collectors don't even know. Michael Yates, court here is on it with PRA. Got court officers changing summons, issuing in court. Keep a paper trail, register by mail. Get everything in writing. If you see something, again, back to what I was saying, write a letter. Say, hey, I noticed you made a change here. What was the rule, by the way, that says you can just arbitrarily come and change something? Could you supply that to me, please? You've got to put it in writing. What a pain in the ass, right? But it'll save you down the road. SEC has sent me 60 SESS. Could that be security credit? It sent me 60 emails, 9 texts, 3 calls, sent them and they have not responded. Yeah, go look at the new rules. You're only allowed to do that 7 times, including emails, 7 contacts a week. I believe it's a week. I did a video on it. Rubio, you're all over this. Give somebody else a chance. Do banks like Chase have thresholds for deciding to charge off or sue? Those are many different questions. A couple of years ago, what they do is they hold on to some, they send out debt collection letters from different firms. They get as much information as they can and then make a decision whether they're going to sue based on that information, based on your credit score, based on algorithms that are now AI. So there's many factors that go into that. LaRubio's at it again. Come on, LaRubio, give somebody else a chance. Michael Yates, it's fraud. Okay. Rena, charge-offs are removed from their books according to Accounting Sense. None of them have standing to sue in their own name. That's not quite true. The issue is you, not them. You still owe the debt. Were it waived, you've had a nice letter from the IRS. But there's ways to get out of it. So, Elmond, original creditor OC closed and charged off my account. I've done videos on charging off and what it means. They reported to CRAs, disputed and sent to CD. OC reopened account, increased amount due, changed closing date. But if that, here's the rule on cases with CRAs, FCRA, but Consumer Credit Reporting Agencies, if it's either false or illegal, false, inaccurate. So if something's not accurate, send a dispute letter. If they don't fix, you have an FCRA case, but you have to give them the buy the apple. The law requires you give them 30 days to fix. So load that dispute letter up, send it to all 3 credit bureaus and the furnisher, meaning the OC that's putting the bad stuff on your credit. Certified return receipt requested. Keep copies of the letter that you signed and wait to see if they lie further, because now it has legal ramifications. Dirt Donkey. PRA case dismissed once for no documents. Refiled 4 months later, no documents. If I file dismissal again, will they keep refiling? No. You just have to show perfect. That's what I was talking about, the synopsis for the court. On July 15th, the court dismissed this case without prejudice because there was no documents. On October 15th, it refiled with, again, no documents. At this point, this case should be dismissed, then add law and rules, and the court will take over. We have come to an end of the questions. Oh, someone just dropped one in. Somebody says, hey, LaRubio, stop asking questions or something. Sign up for Killed It. And it's right. And maybe LaRubio has it. Brian created ParkerGPT. It's like having him on your side. Thank you. That's kind of what I wanted to do. You skipped over me. LOL. Keith C6378. Keith, if you want to just ask me the question again, do so. Let me just see if I can see your question. Oh, being sued by actual credit card company. I responded to the civil complaint. I wondering my next move. When you say respond, I hope it was an answer, counter affidavit, and affirmative defenses. The next move is not yours, but generally it's the court. Check your rules. And the rule is they will send you a notice for a pretrial to come on in and talk about your case. Generally, I've got plenty of videos, even one that says Cap 1, how to make your first appearance, pretrial. The thing about Killed It is if you have a specific event, let's say you're going to a pretrial, go to the cheat sheet and say, hey, I've got a first pretrial. It's against Cap 1. I'm a little nervous. Here's my answer. Create a cheat sheet of what I should say or not say or focus on for the pretrial. And it'll give you a cheat sheet. Take away the anxiety. One of my favorites here. XYLISTEP32. Will you be able to answer my question? Oh, let me see if I got an icon. I do not want to jump over you. That's what he, she, they said. Thank you. That's a bad joke. So, tell me your question again because I don't see it. Michael Yates, it started by them serving my ex-wife at her home. I have so many cases like that turn out great for you because they served your ex-wife at her home. I've done those specifically. By the way, be plain English human. That's a great set of facts that a court will, because let's say the guy is divorced. He goes, he will feel that. Any divorced man or woman will feel that in their gut. There are some relationships that end badly and you do not want, now they just told your ex you're a deadbeat, right? And the judge might feel that too. So yeah, that's a good set of facts. I'm signing up as, Kamish 9002. I'm signing up ASAP. I have 30 days to submit my answer. You got time, but you're going to love it. It's just great. There is a Maryland class action says, I am tardy. I don't feel tardy, Van Halen. There is a Maryland class action lawsuit against Continental Finance. I have a couple of charge-off cards that were sold to Midland. Can I challenge because of the lawsuit? Why would you? And I don't mean to be rude, it's a long day, but Midland on their own, don't bring in the credit nonsense. Now, if you see in the class action, you can go, they'll have a website telling you about the class action. Yeah, they're selling bad debt without proof to people. Now that goes in your defense. But and I say that because this opens up a door for me. Someone comes to me and says, I got a Midland case, and I pulled out the securitization. I sent a letter to Citibank. Don't. You do not want the debt originator in this case. Midland's effed up the case plenty for you. You may legitimatize Midland, whose argument is, yeah, we legitimately bought it from them. And now you're arguing and helping their cause. You got a Midland case, put your legal blinders on. I don't want to know from anybody else. It's Midland. The only thing you need to say is they don't own the debt because there's no proof Citibank sold it to them. And also it says in the bill of sale, sold without recourse, meaning legally you can't touch us, Citibank says that. And without merchantability of title or representation, as is. That's the only reason you'd bring them up. Decker Rick. Case was filed as breach of lease. Found title, I don't. Francella, Wells Fargo attorney sent me a letter in May 2025. I demanded to validate it. They responded with a box of statements and an agreement from 2/16. They didn't validate. Great. That's your defense. And show, look, Your Honor, they're suing me with the wrong terms and conditions. They say I violated, and I can use their own documents to show this, among other things. XLISTEP32 said I jumped over their stuff. Velocity purchased my account from OC while OC had a suit against me for over a year. Interesting. I'm counterclaiming against OC. Should I pursue Velocity too? I would go after Velocity because how do they own the debt that's currently in a lawsuit? And you can double up. You can use both things you're using. But Velocity cannot claim they own it when you have a lawsuit from the people that really own it. You have to have standing to sue, meaning you have to own or have proof of ownership or assignment. It's impossible for Velocity to have standing to sue you if you're currently being sued by the original creditor. I love that case. Case is, I'd file a federal action against Velocity. You can make some money on that. And just Francella, I attached all my kids, what I've done and agree. Oh, good. Okay. Francella says ParkerGPT says they breached their own agreement. That's when it told me to file a motion to compel first before I file my answer. ParkerGPT either is wrong or the information you fed it needs to be updated. You don't file a motion to compel until there's a lawsuit, meaning you and the other guy are in the case. So you'd file the answer first, or your motion to dismiss. Mr. Cat. Florida case, Chase counsel summary judgment motion. Ouch. Chase wants a telephonic hearing stating hardship on their part. I don't understand that. Any defense moves to object. Yeah, you need ParkerGPT. That's my answer. Not being flippant, I've been answering, but that'll take a while. But ParkerGPT is a lot cheaper than an attorney. Judge says, Rena, all evidence must be provided to the court 7 days before the trial date. Can I add exhibits that I didn't necessarily discuss? The way I read that is, unless there's a dispute over your documents or you're required to give your exhibit list and it isn't on your exhibit list, you're going to do an amendment of your exhibit list and make sure you get those new records before the trial date, 7 days before. I am tardy. Should you sue third parties for placing those accounts on my credit report, or should I wait until they attempt to sue me? If something's on your credit report and it's false, I'm sending a dispute letter, then I'm suing them. If someone sues you, that's an FCRA, FDCPA counterclaim against the person suing you with those debts. I lost summary judgment, says, whoa, due to failing to add a counter affidavit. Ooh, okay. I filed 59E motion to vacate his credit application did not match billing statements. They sued on a Visa instead of an Amex. Who the heck ruled against you? They got the wrong guy. Oh my goodness. You should get that set aside. I would emphasize strongly, without being disrespectful, what you just said at the very beginning. I would even go find the Amex people that sue on Amex and put their names in the motion saying that firm sues for Amex, this firm sues for Visa. That's not even the right firm. I mean, you add some gristle. What happens next, JC Michael asks, if we get to the end of all court legal proceedings and they decide in the bank's favor? If you've done a good job, you get to appeal if you know they should not have gone against you. DBento63. And by the way, the appeal, I'm going to say this, but it's not what it is. You say to the other side, hey, look, here's where they court screwed up. I think I got an appealable issue. In fact, here's a case. Before I appeal, you want to see if we can settle this? You say, oh, $100. If you do 50 over a 12-month span, 12 months, we could settle it. So a threat or a filing of appeal may help you settle it. I'm not saying what to do. I'm just telling you what happens in my life. Although I'm going to do my first appeal in a long, long time. I know the judge is wrong. Every attorney says that, but I literally do. Well, until the appeals court says I'm right, I guess she isn't. Something I discovered in ParkerGPT, says D-Bent, is that he cannot cross-reference the chats. If you start a different chat related to the same topic, you'll have to provide details again. See every single chat box in this world currently. And there's a reason for that. Because you will not get the answer you seek if you include a mishmash of disjointed other facts. You'll get an answer you don't want. You want to specify. Now, my kid, who's an AI genius, I'll stop there. I have two geniuses. One is an AI genius. The other is a cybersecurity genius. He says, Dad, here's how you go wrong. You ask it to do what it's doing, and you give it the upload of the documents. But to really get a good job and to save yourself time, Dad, ask it questions. Go, have I given you enough information, or do you have questions for me before you produce what I want? And that has changed a lot of how I've interacted with ParkerGPT. So give it what you want, prompt, say this is what I need, here's the uploads. Do you have any further questions of me? It will produce either those questions or it'll say, nope, you gave me everything I need, and that'll clean it up. But don't mix your chats. The first thing that people mistake, the first mistake I believe that people make when they first start using AI chats is they open up and they say, hey, is my girlfriend seeing somebody else? And then they'll go, can I get a Porsche with a stick shift? And then they'll ask, iPhone, what model's the best model? It takes all that information. So separate your chats. So you don't have to have a special device in ParkerGPT or anything else. Know that. Separate your chats for the best response. Meaning, not every time you ask a question on the same chat. but separate your inquiry chats. I hope I've said that correctly. If the developer's watching, he'll let me know what an idiot I am. As I said that, something came up, but no, that's not it. So, general question: can my mortgage be reported on my credit report twice? No. Is it? You gotta. If it's not true or inaccurate, send a dispute letter. Yo, BP, says Aztec. What do you mean the local law firm should pay? If I followed the answer by myself using ChatGPT, hired a law firm after CMC, we beat them. Dismissed with prejudice, though. You beat them. You should sue. Oh, I see what you're saying. Okay. You hired a law firm afterwards. I'm saying jokingly, you did most of the work. They should pay you back whatever you paid them. Would you bring an action against the original creditor because it sold a debt to unfair debt collector? No, unless they are doing something illegal, meaning, by way of example, I'd do a third-party claim if they were pretending to be a debt collector and they're also claiming their creditor, therefore you can't sue them. For example, you always hear me preach, if a creditor sues you, and then on the bottom of the lawsuit it says, we are debt collectors. Anything you say will be used for that purpose. Generally, the law firm has put that on there to protect themselves. But by virtue of the fact that the law specifically says don't do that if you're a creditor, they can't say they're actually pretending to be debt collectors to bust your chops while claiming to be immune from the FDCPA by saying we're creditors. So yeah, you can use that against them. D. Benton says you have created a wonderful resource. Thank you. We have not heard from Suddenly Rubio disappeared. Maybe he's off signing up for ParkerGPT. I have an upcoming trial. I received exhibits in the documents provided of Exhibit A, bill of sale, and Exhibit K. Oh, I know what that is. It's a Velocity case or Crown Asset, which shows a chain of sale. In the text, Exhibit K, it says there isn't a. Yeah, I know all that. See all my videos. And you want to even more fun? It'll say, let's say it's Cross River Bank or Blue Ridge or Finwise. Finwise is the transferor. We transfer the debt to the transferee, and then they don't name who the transferee is. I kid you not. That's the every Exhibit K. You win just on that alone. Look at the signature. Look at the statute of frauds. What does it say for an assignment to be true? There's lots of ways to win that. Attorney representing Midland authored an affidavit naming one original creditor and then authored an alias plurius with the same original complaint, yet that names a different creditor. Great! Factually, they got to have an assignment, and you've got great facts to win that. Collection stopper. Oh, I'm being told we have implemented cross-chat memory. If I'm not too big of a dummy to understand that, someone was asking about mixing chats. I'm now being told we've implemented cross-chat memory. Tell me what that means, whoever just wrote that to me. It's one of I think it's the developer. Hi, BP. What is the best defense I can prove my identity? What time is it? Holy cow, we've been going in and out. I'm going to have to slow this down soon. If BP, what's the best defense if I can prove? We still got 67 people. What is the best defense if I can prove my identity was stolen, but they are continuing the suit? I have a trial in 2 weeks. Defense. You ever see that show, that coach where his team was playing really bad, and the press says, "What do you think your chances are now of getting the playoffs?" And it's what's his name? He says playoffs, and that he made tons of money just on commercials saying playoffs. because his team was so bad. So I would say, in answer, defense, you got a counterclaim. You've got a lawsuit again. I'd file a lawsuit against them if you're still in the statute of limitations. If you have an identity theft, you've got bigger problems because you need to go to annualcreditreport.com and see if you've got anything else on there, because identity theft is the gift, unfortunately, it just keeps giving to someone else. But you should have done a whole bunch of stuff that I counsel. I'm sorry if you haven't. You have to have filed a police report. No one's going to believe you. You got to file an FTCPA affidavit, FTC affidavit, and make sure the other side knows this. I hope you've done all that. And that's a great defense, yes. But you've got playoffs, you've defense, you've got an action against them, an FCRA, you've got tons of money coming your way if the facts are correct. Are you still taking cases in Michigan? I'm generally not. I take generally debt buyer cases from old clients, but this thing is overtaken my life, this killdebt.com, and it's killing me to handle 2 states as a lawyer and do this. I love this stuff. Thank you but I will take debt buyer cases because they're so easy. Are you still taking debt? Okay. Thank you for your help in this space. You are showing us all how to defend ourselves in these consumer streets. There's probably, other than my age, is probably, and maybe I haven't seen some stuff that you have, there's nothing that you've been through when it comes to debt that I haven't personally experienced, and also putting my head in the sand like a ostrich. So when I became an attorney, I didn't forget. Very quick story. When I became an attorney, I still had some issues, and an attorney sued me for Citibank. He's still around today. You better believe I have fun with that case. Of course, I follow the rules. So I know who I am, and I know who you are. And I try to give you as much as I can of what I went through and the solutions that I wish I had. And that's what you got. Glad you added a cross-chat memory. I seem like an idiot. But I don't know development. I know debt defense. You know? The OC sued, not Velocity. Velocity sent letter to me to collect. Should I sue OC? I'm not going to you mixed the facts, so. Hello, Parker from Wisconsin. I love Madison's a blast. You have helped me so much. I can't thank you. I can thank you enough. I think you meant I can thank you enough. I can thank you enough. I had that reminds me of mixed words. Let's say I had an ex, and I remember telling her one day, you know what? I don't deserve you. And that's a loving thing to say to somebody. You know, she's so great. I don't deserve, but that I meant the opposite. So I can thank you enough. I think you meant you can't thank me enough. See, this is what happens when I work all day. I started at 6, 7 this morning, and stuff's kicking in. I have a notice from a Discover. It said, hey, XYLSIST. It said you were suing, Velocity was suing you. Don't make me go back. I'm OCD. You just messed with me because I'm OCD. Now I'm going to have to go back. I swear you said Velocity was suing you, and it was such a great defense. But I accept your truth. Now I'm going back. I got work to do here. Velocity purchased my account from OC while OC had a suit against me. I'm counterclaiming against OC. Oh, I see. Should I you're right. Big dummy. Gosh, I'm so sorry. Astute Millite. Okay. I didn't mix the facts. She says, you're a big dummy. No, she didn't say that. She says, you misread it, love, but it's okay. I appreciate you. Okay. But I'll tell you what that is. You still have a lawsuit against Velocity if they're pursuing you under the FDCPA for a debt. You're currently in a lawsuit because somebody else owns it. So I bet you've done this. But if you send them a validation letter, two things are true. They're going to go away. If they send you stuff saying they own it, they can't. Don't tell them about the other lawsuits because they'll change stuff. And then you can sue them. I love the app anyway, but I love the app anyway. Thanks, Michael. You are not a big dummy, Captain. I know who that is, Captain. Okay. Okay, we've come to the end. There are 67 people still here. But I have to go. If anybody has any questions, I'm such a giver. Oh, let me give you some more help, if you're listening at least. Bill of sale. 4 tips on a bill of sale. Is your account number or name in the bill of sale? If it isn't, why is it a bill of sale of your debt? Is the bill of sale claiming to be an assignment? Like sometimes they'll go, bill of sale and assignment. Better follow the rules of statute of frauds, meaning them, because the statute of laws lays out exactly something in writing for it to pass something. Check out your state. There's some great. I can't say enough. No one's asking. Please check out your right to cure rules. Check out the right to cure video. Damn, is that powerful stuff, especially in Wisconsin, Madison, and South Carolina. They're not even allowed to file a lawsuit against you. And the cool thing is, if the debt buyer that bought the debt 10 years ago, they have to file a right to cure or show that the other side did. And the other side said, you take this, we're not handling this anymore. The right to cure is awesome stuff. Watch my latest video. It is called Why I Don't Trust ChatGPT. I changed that name a couple of times. I didn't want to defame anybody, but what I'm trying to show you is you can do it for free, but ChatGPT will give you an answer that the internet wants you to have. ParkerGPT, and I outline exactly the great ways compared to ChatGPT that you benefit. It's like $5 a day to get your ship right and to beat these guys. I'm plugging just that one time. Okay. Read all, please. I have a notice from Discover saying that they will forward to an attorney August 28, 2025, after alleged merger date with the debt collector statement claim at the bottom. Rena, would you send that to me and I'll make it available to anybody that wants it? My email is brian@killdebt.com. Rena, I hope I got accused of not reading properly. You're right. I should be wearing these. Oh, what a dork. So that's why I'm missing stuff and I'm tired. So Rena, if you can send that, I'll make it available to everybody. I'll put it in ParkerGPT. If they sue on one account number, but the original is different, is that a shutdown also they haven't showed standing? Well, I like the standing better, but a lot of times, but if it's right in front of you, you use it. They later may say, oh, we changed the account number. Okay, show us how you did that. So you can open a door that they will try to close, but as they're closing it, it will be one of those doors that swings right through. And now you'll be exposing them. So yeah, I love that, but I love the standing issue so much better. However, the account number one, if done factually right, will buttress and support your standing one. Rena says she is sending me that information. I will have Natalie upload it to the video that we just did on the merger just last week, or this week. I'm forgetting where the week is. And then I'll put it into ParkerGPT so you can use it. Anybody's got a merger case, I'll get it uploaded to you. If you really want me to do this, email me at ParkerGPT and I will email you a letter. And when I get those emails, I am going to regret that. because I have so much going on during the day. But I'm a problem solver to my own detriment. So don't inundate me. I'll put it into ParkerGPT. Please, Rainer, I need that, says Kemi Shack. I know I've talked. Okay, I'm coming to an end here because I'm saying stupid things. I want to thank you for your attention. Still 64. I wanted to finish the forward flow agreement, the bill of sale. Ask for that forward flow agreement. They do not want you to have it because it details exactly how the sale went down, pennies on the dollar. But every bill of sale says forward flow agreement or master purchase agreement, and the bill of sale is based upon it, meaning it'll say this bill of sale is pursuant, and something that is pursuant to has to be available to you. Otherwise, the bill of sale isn't legitimate either because it's pursuant to that thing. So you say to the court, I'd like that thing that it's pursuant to. The court will get that. They don't want to give that to you. You'll settle that case. Number 4 of the bill of sale things to pressure on. And when I did a lot of martial arts, there's a lot of stuff going on with the neck. 4, the signature. We'd have this thing in martial arts where they wanted us to punch the guy in the throat a certain way, but you do it with 2 fingers. It was called the room clearer. So you're here and all the way across the room, someone's hurting your kid, but you got all these people in your way. You're not going to get there. So you have what's called, they taught us this, a room clearer. And you just go right into the throat of the person, and it's like the parting of the Red Sea. That's the way he described it. Boom, 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 boom. And you just, it's disgusting that was taught to get to your kid that's being hurt by the bad guy, and these people are stopping you. Yeah, it's got to be some confrontation. So you do a room, and that you can do that to anybody in defense. And that's the same thing with this. You do a room clearer, go right into their throat. They do not want to give you this. I swear to you, they do not want to give you the forward flow agreement. It's their Bible. It's their secret. And that's exactly how they would defend against that. And some judges will give it to you. You will settle that case. You may want to ask for a couple of dollars too. That room clearer that I would learn in martial arts, they would make us do it for real. So at the end of the night of the lesson, you'd be in pain for days. It's a very serious guy that ran this place. But that's your room clearer, all right? That's your bill of sale clear. That's your case settler. Got to scan it. We'll send it. Thank you. Okay, I'm ending it now. Thank you, everybody, for your attention. I hope these tips were helpful. How can I get these? I'll put these in ParkerGPT. But you don't need it. It's all in ParkerGPT. I just wanted to give you some extra stuff. So I'm going to say good night. Somebody did a room clearer to me. So good night, all. Thank you very much. I'll do this again next month. I hope this is helpful. Drop me a line if it was. I'm going to turn this into kind of a cool video, kind of make it better for you. And if it was helpful, put it in the comments. I hope it was. Thanks all. Thank you all. Y'all saying thank you now. Thank you kindly. We did this so long. I have 2 cameras going. They ran out of batteries. I shouldn't have done this so long, but I can't. I'm such a giver. Okay, so use Parker. Hey, no. I got to do this. Hey. Fast Eddie. Hi, Fast Eddie. I forgot to mention your name. Sorry about that. Hold on. I want to say goodbye to this one person. Okay, I'm wasting time. This killing time's just killing me. Okay. Okay, LaRubio. Someone told him to get, or her to get ParkerGPT. LaRubio, you need to get ParkerGPT. It'll help you. Okay, thank you kindly. Bye now. Be good.